Good morning, Mr. Knight. I just realized. Good morning, Mr. Knight.
Yeah.
Okay, there we go. I bet I'm not the first person to mention that to you. My apologies.
No problem. So as the court mentioned, I'm Stephen Knight, representing the plaintiffs and appellants, Jim Spangler and Hidden Valley Homes. I'd like to reserve 5 minutes for rebuttal.
5 minutes, yes, sir.
So this is a case to enforce a simple oral agreement to split attorney's fees. The Oldsmith parties and the Hidden Valley parties had a common interest in enforcing an agreement for the sale of land. They agreed to hire a lawyer, split the fees and expenses from that. And most of the panel, I'm guessing probably all the panel, is well aware of what happened in that case. Became much more complicated than the parties expected.
Definitely.
33 pages of opinion complicated, I would say.
Exactly.
Yeah.
Exactly. But this case, again, just relates to this simple oral attorney's fee agreement. And at this stage of the proceeding, the court has to assume that there was such an agreement. The existence of the attorney's fee agreement wasn't challenged in the trial court. The trial court didn't rule on whether or not there was such an agreement. What's at issue in this case is whether there's another agreement that makes the attorney's fee agreement unenforceable. And that's the assignment agreement, and specifically paragraph 4 of the assignment agreement. That's set out in full on page 14 of our primary brief. And that provision doesn't really require any interpretation. It's not ambiguous. I think you might say it's potentially confusing, but if I can just clearly communicate to the court through the briefs and through our discussion today what the Oldsmith party's position is on that and what that provision actually says, I think it'll be clear that the assignment agreement has no relevance to the attorney's fee agreement, and in this case needs to be sent back to the trial court. The way we got to the assignment agreement is that there was a developer, Mosby Cool Springs LLC, that was developing some property in Williamson County. It's referred to as seller in the briefing because that's sort of its role in this case. Mosby sold a portion of the land it was developing to Oldsmith to allow Oldsmith to develop it. And this wasn't a simple exchange of a deed for money because of these development activities. The idea was that Mosby would develop all of the property to the point where it was ready for building. So the sale agreement required the seller to take care of things like grading, putting in water lines, streets, and that sort of thing. And then at the point at which it was ready for construction of buildings, Oldsmith would take over. So the sale agreement puts a lot of obligations on the seller to do work, but it also imposed some obligations on the buyer, Oldsmith, to do some things to prepare for the development, because since it would eventually be building, it had to do things like work on plans.
And was this an argument, the scope of the assignment made to the trial court? Because I don't see a lot of analysis in the trial court's memorandum in order on the scope of the assignment. It almost seems like it's a given that the assignment controls, and that instead the argument was the engagement letter from Sherrard and Rowe somehow superseded the arrangement.
And so, Your Honor, I think that is part of why we're here today. Certainly, we argued to the trial court that this assignment provision did not apply to bringing a lawsuit against the seller. I think that the problem is the trial court never let go of this idea that we were maybe enforcing this retainer agreement, or the characterization by Oldsmith that this assignment agreement was just sort of generally a requirement that they help in getting this deal done.
Okay, and there was a declaration from the attorney filed in response to the motion for summary judgment, Welch, is that right?
Right.
Was he with Sherrard and Rowe at the time, or did he join later?
No, Mr. Welch was initially hired to handle the whole case. He's on his own. He had a retainer agreement with Mr. Olderman, and the parties hired him to file the case. Later on, they moved the case to Sherrard and Rowe, and then signed retainer agreements obligating Hidden Valley and Oldsmith
Oldsmith.
to pay those, right? And really, to us, that's just, the significance of that is just evidence that there was an attorney's fee agreement. I don't think before this court it really has any particular relevance other than that. We're just enforcing, again, just an oral agreement. We're going to split the fees and expenses.
And the nature of the oral agreement, I'm focusing on the parties here now, was both Olderman and Oldsmith was obligated for this 50% share.
Correct.
So I'm trying to figure out why would Olderman do that?
Well, two things. One is, that's not.
I mean, I
before-
appreciate his entity
Sure.
would get something if this sale went through, but what benefit does Olderman have saying, oh, well, I'll get on the hook personally here?
I understand, Your Honor. Well, so two things. One, I don't think that's before the court. That wasn't raised in the summary judgment motion. But to answer the question, so these are developers. They create these single-purpose entities to do these deals to try to insulate themselves. So when you've got two developers who are making an agreement to do something, each side wants the other individual to be responsible. They don't want this single-purpose entity being the one that's responsible for paying. And that's going to be a point of dispute when it's sent back. I'm sure Mr. Olderman's going to say, no, it was just the entity, it wasn't me. But again, I don't think that's before the court. The question before the court is just.
Well, and that may be true. I'm just trying to figure out what the incentives here were.
I think
for
it's
that
because
happen.
Mr. Spangler wanted Mr. Olderman to be responsible.
Right, I understand on Spangler's side, he wants to have as
Well,
many
but
people
it's
obligated
reciprocal,
on the other
because
side.
Mr. Olderman wants Mr. Spangler to
Yeah,
be
right.
on there, so that's why they would both agree to that.
Mr. Knight, a moment ago, I think you said our single purpose is to enforce the oral agreement in this appeal. I think, I'm not trying to limit you, but if that is the case or partially the case, why doesn't the statute of frauds apply to this oral agreement?
Well, so the statute of frauds doesn't apply because the Oldsmith's theory is that it applies because this assignment agreement is subject to the statute of frauds, and paragraph 4 of the assignment agreement applies to this attorney's fee agreement. And our position is paragraph 4 of the assignment agreement has nothing to do with the payment of attorney's fees in the event of some future lawsuit. And the reason I say that is, the reason I was emphasizing what the buyer's duties were under this original sale agreement is that's the subject matter of paragraph 4 of the assignment agreement. What the assignment agreement does, it's one sentence, and it's kind of a funnel. It puts an obligation on the assigner, which is also the buyer, Oldsmith. They have to help the assignee, Hidden Valley Homes, completing the obligations under the sale agreement. The things like getting things through the planning commission, negotiating covenants, and this sort of thing. They have to help with that. Now that is limited, provided that, and this is all one sentence, they have to do that provided that any third-party expenses have to be paid by Hidden Valley Homes. So for example, if they have to pay engineers, if they're paying lawyers to take care of these tasks that they're obligated to do under the sale agreement, then Hidden Valley will pay that. So Oldsmith's argument is, well, attorney's fees are third-party expenses. Those are covered by that. Well, it's not any third-party expenses. What we're talking about is third-party expenses incurred by Oldsmith performing its obligations under the sale agreement. So these are expenses incurred fulfilling obligations to the seller, to Mosby. In order for that to apply to the attorney's fee agreement, Oldsmith would have to have an obligation to Mosby. Buyer would have to have an obligation to seller to sue the seller for breach of the contract. It just doesn't make any sense. Hidden Valley is agreeing to pay third-party expenses incurred performing the duties under the sale agreement.
Let's say we agree with you that the assignment doesn't cover this expense, and so statute of frauds doesn't apply here because it's not a real estate transaction. The court also had an alternative theory for why the statute of frauds would apply, and that he deemed this, or the court deemed it a contract of guarantee.
Right.
Why is this not a contract of guarantee?
So Oldsmith practically abandons that argument on appeal, and the reason is there's several problems with it. One is the guarantee, the pattern for that is promise to pay the debt of another. That is a promise to the creditor to pay the debt of another, the debtor. Even as Oldsmith wants to characterize this, what this would be, assuming that this is Hidden Valley's, the attorney's fees are Hidden Valley's responsibility, which they're not, this would be a debtor trying to enforce an agreement to pay the debtor's obligation. So it just doesn't fit that pattern. In addition, it's not Hidden Valley's debt. These are at best, the obligation for attorney's fees are at best joint obligations, because the attorney's fee obligations are one to Jack Welch under a retainer agreement that Mr. Olderman has with Jack Welch. Only party who's obligated to Mr. Welch is Olderman. Second, the Sherrard and Rowe, the obligation to pay the Sherrard and Rowe attorney's fees are based on the retainer agreement, which are both Oldsmith and Hidden Valley. So those are joint obligations. Joint agreement to pay joint obligations are not subject to the debt of another statute of frauds provision.
All right, thank you, Mr. Knight.
Thank you.
We'll hear from you on rebuttal. Good morning.
Morning, Your Honor. Ben Goldamer, represent Oldsmith and Chuck Olderman. The core issue, I think, for the court is whether the court concludes that Oldsmith intended to give Hidden Valley Homes a blank check for legal fees to enforce a purchase and sale agreement that had been assigned where its only conceivable upside in this is $75,000. The case obviously is a breach of contract case, and the fight has centered around this issue of formation of the contract. And so getting to the issue of formation and intent and what the parties intended this assignment to mean, we obviously start with the four corners, but we don't stop there. We can look at circumstances, we can look at the course of conduct. My client's position throughout this case and prior to this case has been consistent, and that is that the obligation to pay the attorney's fees was assumed by the plaintiffs within the assignment agreement. The intent of the assignment was to effectively pass the baton, and not uncommon in contracts.
Yet in the underlying litigation, your client is carrying the baton.
Because I think they had the obligation to carry the baton, or at least to provide support for Hidden Valley to carry the baton.
And on top of that, your client is representing to the court. In that case, we've incurred attorney's fees. When you're saying, no, we haven't, other party incurred those attorney's fees.
Well, I mean, that was certainly the declaration that was filed in the fee application, but at that point there was no issue of my client owing fees because my client had never paid the fees. My client had told everybody in writing back in 2021, I don't understand why you think we owe fees. This has been assigned. Is
there any factual dispute here that your client was receiving fee statements from Sherrard Rowe?
It's not disputed.
Okay.
Nor is it disputed that we received them from Jack Welch. But our position again is that the read of the assignment, coupled with the circumstances in the course of conduct, is that my client certainly viewed himself as having passed the baton. He had an obligation under the assignment to provide good faith assistance and to continue to cooperate, as we commonly see in contracts.
And so do we read that provided clause in the assignment in the context of completing the responsibility of the purchaser, or are those really two separate obligations under the assignment?
Well, I think they function.
Because I have to say, the reason why I'm asking you is I don't want to trick you in this, but I find some appeal to the argument that, look, filing suit and pursuing a breach is really not a responsibility of a purchaser under acquisition contract for land. or development, there's certainly a lot of responsibilities, or can be a lot of responsibilities assigned to the purchasers, but filing suit is really not one of them.
Yeah, I mean, I think that the parties certainly could have been more artful when they drafted it, but I think that the circumstances, the fact that, again, I used the analogy of passing the baton, and you kind of rightfully turned it around on me, but that's what they thought they were doing. And with those circumstances and with the overall context in mind, I think you have to consider that when you view the word responsibilities of the purchaser. I mean, this was a suit, and what was affirmed was an award of specific performance. I think that from my client's perspective, he certainly thought that he was helping fulfill the responsibility of getting this transaction to a closing.
And if the transaction ultimately closes, which I guess is TBD in this case, is your client gets some benefit if it actually gets to that day.
The only benefit we get under the assignment is we get a check for $75,000 when it closes. And I'll say it again because I said it on the record at the trial court at oral argument. This is not our contract. We don't intend to come and say we're owed those $290,000. We don't intend to say we get the benefit of the land. That's their $290,000. We don't intend to make a claim for it. So I put that on the table with Judge Woodruff at the trial court level. I'll put it on the table again. It's not our position. We get a penny of that $290,000.
Yeah. But I want to make sure I get your answer to my interpretation question. How do I read that provided clause? I mean, do I have to read it in context with the responsibility of the purchaser? Because again, I'm troubled by, these don't really sound like purchaser responsibilities pursuing this suit.
Yeah, I don't think you have to read them as being coupled to one another. I mean, I think you can.
So you would read them separately.
I think you can get to my construction in two ways. I think you can look at the overall context and talk about the obligations of the purchaser and say that in the overall context that the parties viewed one of their obligations as getting this to a closing. Could they have been more artful about it? Yes, and in that sense, you can couple the clauses. You can also decouple them and say, we were simply agreeing we're not going to go out and incur costs because these are all their costs now, and we certainly won't do it beforehand because at the end of the day, the costs come back to them.
All right, so let's step down then. Let's say I disagree with you that the assignment here controls. Don't think this provides for attorney's fees. How do I get to the statute of frauds applying?
I only think you get to the statute of frauds if you first conclude that the assignment controls.
Okay.
Because that's the only way you get to the argument of trying to fight against this oral agreement that, no, it's actually a contract for the sale of land, so this subsequent oral agreement is unenforceable. No, it's a subsequent guarantee to do something contrary to the assignment.
So you're not going to defend the trial court's ruling there about, well, alternatively, this is a contract of guarantee.
And frankly, I didn't view that as being an alternative argument because frankly, I thought that what Judge Woodruff was saying is he construes the assignment consistent with how I've argued that it puts all the obligations.
Yeah, I'm right, and I agree with that. I mean, he seems like the first way he's going is, look, this is an assignment contract for realty. Statute of frauds, it's got to apply here if it covers. Yeah.
Yeah, I don't.
Was there an integration clause in that? In the assignment?
I don't know, but it would have been, I guess.
Because that would have been a lot directer route to go on this if there were. Why do you even get to the statute of frauds? You go, look, there's an integration clause. You don't, this oral agreement doesn't help.
I've got it in front of me, and I don't. No, it doesn't have one.
I've slept since I've looked at it too, so yeah, I don't blame you.
It could have been better drafted. So I'll move on, and I at least want to touch on, what I started by saying is that my position, if nothing else, has been consistent throughout. It's been consistent from when I got involved in 2021 to the present, but the plaintiff's position has been somewhat of a moving target. Because the plaintiff originally files this complaint, And there's no reference at all to Jack Welch in the complaint, the prior lawyer. There's not even a claim made for fees associated with Jack Welch. The focus is solely on the Sherrard Rowe fees. And in fact, in paragraph 11 of the complaint, what the plaintiffs plead is that the parties signed the retainer agreement. I think it's actually an engagement agreement, but they signed the retainer agreement, and that obligated them to share fees.
So who got the two clients to Sherrard Rowe? Was that Hidden Valley or was that Oldsmith?
I believe that they both had a pre-existing relationship with Todd Panther,
Okay.
who had done work for them kind of intermittently in the past, and they said maybe this would be a good fit.
That's it.
But the position, like I said originally, was nothing about Jack Welch and nothing about any agreement with Jack Welch, and that the contract at issue was the Sherrard and Rowe engagement letter. And the Sherrard and Rowe engagement letter doesn't say anything about allocation of fees or sharing of fees. It's just a vanilla engagement letter. But on summary judgment, the position seems to change, and it's now a verbal agreement, and that crystallizes, particularly in the plaintiff's argument here, he opens with this is solely about enforcing an oral agreement. That's not what's in the complaint. And if you even look at the affidavits that Mr. Spangler submitted in opposition to summary judgment, what he says in paragraph 4 of his affidavit is that we agreed to split fees on Welch, paragraph 4. Paragraph 11, he doesn't say we agreed to split fees on Sherrard and Rowe. He says we signed an engagement letter with Sherrard and Rowe. And I make that point because the entirety of this lawsuit is about Sherrard and Rowe fees. There's never been a claim within the complaint for Jack Welch fees. And what they're trying to do is they're trying to tie this purported agreement that they reached with Jack Welch back to now a subsequent agreement with Sherrard and Rowe. But there's absolutely no testimony in the record that they reached this same purported oral agreement in relation to Sherrard and Rowe.
So that's an interesting argument, but it's not one that the trial court relied on in its decision.
No, it is not. But I think the court could, and part of what I argued in my reply, I know that the plaintiff says I didn't make this argument at the trial court level, but frankly, I cut and pasted the argument almost verbatim from my reply brief into my Court of Appeals brief, is I argued at the trial court level, there is no admissible evidence of this oral agreement. And I argued that in my reply. I argued it again at the Court of Appeals. And I made this point. I said, look, the declaration of Spangler, the owner of Hidden Valley, it conflicts itself. It's self-serving. The declaration of Jack Welch is premised entirely on hearsay. He says, I was told and understood that each of the clients would be responsible for half of the legal fees. And so I made this, I objected to their statement of additional facts, citing case law and the rules related to hearsay, and fully briefed this at the trial court level. So yes, I agree the trial court didn't hang its hat on this, but the trial court could have said, and I think this Court of Appeals would be within its discretion to say, the testimony of Spangler doesn't get us there, because he doesn't say there's any agreement related to Sherrard and Rowe. All you can point to is the pleadings of the complaint, which are not sufficient on summary judgment, to say they signed an engagement letter which doesn't say anything about sharing fees. It doesn't get you there. Jack Welch's declaration is hearsay. It doesn't get you there. And I made these exact arguments at the trial court, and I think that the Court of Appeals could very well say that there was just a total vacuum of evidence on their side in opposition to our position. Why? Because we go on from when I send my letter in 2021, and they don't put anything in the record to say, a text, an email, something back and forth between Olderman and Spangler saying that's not our deal. We got my letter from 2021 and then a total vacuum of evidence. And I think it's telling that Mr. Spangler's affidavit doesn't say point blank, we did that same oral agreement again when we went down the street and hired Todd Panther. I think that's telling. And I think the Court of Appeals could have.
So Spangler's affidavit only establishes an agreement, possibly, and I understand you're not conceding this, with Welch, and that's it.
Yeah, yes, I'm saying that in paragraph 4, he says, yeah, I'll give it to him. He says, we agreed to share legal fees. And then he says in paragraph 11, when he gets to talking about hiring Sherrard and Rowe, he says, consistent with our prior agreement, we signed a retainer letter. Well, that's not saying we agreed again. It's just pointing back to the same engagement letter that was in their first theory of the case, when they filed their complaint, it was attached, that they're now retreating from. That's my point, and I think the Court of Appeals could affirm Judge Woodruff on the fact that there's a vacuum of evidence. There's a put up or shut up position here. The last thing I'll address is Mr. Olderman being a party. These are not single purpose entities. I've sued Hidden Valley Homes in litigation for at least 10 years. So I've been fighting with them in other cases, and I've represented Oldsmith for the better part of 10 years in various cases. And Hidden Valley Homes builds multi-million-dollar homes. They have for years. Oldsmith is a developer. They do development everywhere. These are not single-purpose entities. The reason that they sued Chuck Olderman personally is because they thought it would give an end run around the assignment. They thought if we say Olderman was a party to this deal, we can say Olderman's not a party to the assignment, so he agreed to pay legal fees. Judge Woodruff admittedly went off on a little bit of a tangent about piercing, but prior to talking about piercing, he says the engagement letters were signed by the companies, the bills were sent to the companies. I'll point out that Welch doesn't say the individuals were his clients. He said it's Oldsmith and Hidden Valley, and Olderman wasn't a party to the underlying lawsuit.
And I don't know what Olderman would get out of saying, hey, I'll be on the hook too.
I mean, it's a company that is a going concern. Yeah. Both of them are. So I don't think there's any traction there. But I think that that's the reason to answer the question of why the individual was sued. With that, I would ask the court to affirm Judge Woodruff in his entirety, either for the reasons stated in his order or for the exchange we had, Judge McBrayer.
Thank you, Mr. Goldhammer.
Thank you.
Mr. Knight, your rebuttal.
Thank you, Your Honor. I want to start with just addressing a couple of the court's questions about the record briefly. As far as whether we had raised the argument about the scope of the assignment agreement in our response, I think it's fair to say that was the main argument we raised. And beginning on volume 1, page 75 of the record, that's very clearly our argument that this attorney's fees for this lawsuit is not within the scope of this assignment, the assignment agreement. With respect to the assignment agreement itself, whether it had an integration clause, it's a very short agreement, doesn't have an integration clause. That's volume 2, page 235. And so going back to paragraph 4 of the assignment agreement, which I think is the issue in this case, I think the Oldsmith parties are, I want to give them credit for being intellectually honest on this. They in their response, they admit that is the issue. Their argument in the brief on pages 17 to 18, they say that applying the plain and unambiguous language of the assignment, it is unclear how these fees, the attorney's fees, could be construed as anything other than third-party costs or expenses incurred to, quote, complete the responsibilities of the purchaser pursuant to the Mosby Agreement. That's the sale agreement. So their argument has to be, and it is, that these attorney's fees that were paid suing the seller are responsibilities of the purchaser to the seller, which that's part of the challenge here today that I said at the beginning is that doesn't make any sense. That makes it difficult to explain to the court, but that is what their argument boils down to.
Well, but purchaser obligations under a commercial real estate transaction don't all run to the seller necessarily. Sometimes the purchaser has an obligation to get the property platted. The seller doesn't care. They just want the money. So, not all obligations of a purchaser necessarily run to the seller.
Well, and that's true, Your Honor, but from a contractual point of view, it's a contractual obligation, and the contract is with the seller. Now, whether the seller cares, maybe they do, maybe they don't. But if we're just trying to decide what is the universe of things for which Hidden Valley has agreed to pay, provided that Hidden Valley is going to pay the expenses, what kind of third-party expenses are we talking about? It's things that the buyer is required to do under the sale agreement, which
So,
does not include.
Just on the last, one of the last points made, on council, I'm looking at Spangler's declaration now.
Yes.
Paragraph 4, that's what we're writing on for the agreement.
Right.
Okay. Okay.
So, Mr. Spangler, and I didn't pull it up here, and I don't necessarily have it memorized, but I believe that what Mr. Spangler says is that we agreed to split the attorney's fees and expenses. He doesn't say Mr. Welch's. He says, you know, I mean, they're going to file a lawsuit. They're going to split attorney's fees and expenses. They didn't determine only for this lawyer, but if we hire another lawyer, not for that lawyer.
Well,
so they agreed at the beginning.
Yeah, but I guess significantly,
Yeah.
I mean, that paragraph 4 mentions Mr. Welch specifically. It says Chuck, I'll just read it for you.
Sure.
Chuck Olderman, the owner and managing member of Oldsmith Group LLC, suggested that we hire his lawyer, Jack Welch, to compel Mosby to close. Olderman and I agreed that he and Oldsmith Group LLC would pay half the legal fees and expenses, and that Hidden Valley Homes LLC and I would pay half the legal fees and expenses. Now, so on one hand, you want me to read the assignment provision in context with an earlier paragraph. If I read paragraph 4 in that same sort of light, I would say, okay, it's Jack Welch's fees and his fees only
Right.
that we're agreeing
So,
to pay.
so three things, Your Honor. First, I want the assignment agreement provision read. It's just one sentence. I want the sentence read in the context of the same sentence.
Okay,
It's all
right.
one sentence.
Fair enough.
Paragraph 4, there's what it says later on when Sherrod and Rowe was hired was consistent with our previous agreement. The entities agreed, both signed the retainer agreement. So, but the main point is, this is the kind of issue that we're going to be fighting about if this case is sent back to the trial court. It's not before this court. Counsel points out, well, I raised this, that there's not evidence of an agreement in my reply. Okay. A motion is a motion. The grounds were set out in the motion, in the memorandum in support. There was a statement of material facts. The statement of material facts didn't say, oh, we only agreed to split Welch's fees. It didn't say anything about that. It didn't even say there's not an agreement. What it said is, I didn't pay fees because of the assignment agreement. It doesn't say I didn't pay fees because I never agreed to pay fees. That was never part of the motion. Now, is it raised in the reply brief? Maybe, but that's too late. He says there's a vacuum of evidence. Why didn't we respond to that? Well, because it was raised in the reply brief. Wait, that's after we submit our response. That's after we have a chance to submit evidence. That's after we even have a chance to offer anything in writing with respect to that. So that, again, is another one of those issues that's not before the court. And as we said in the brief, I think the reason that there are so many issues being raised that are not before the court is because counsel, as they say in their brief, admit that the real issue is the scope of paragraph 4, and the real issue is whether suing the seller is a responsibility of buyer under its contract with the seller, which is just inconceivable. It's not only inconceivable, but the Oldsmith doesn't even attempt to point to any provision of the sale agreement that they're, to any responsibility they have under the sale agreement that would be subject to paragraph 4 that covers this. They just say, well, in other words, we're supposed to help out, and I can't see how this could be anything other than performing a duty to the seller under the agreement. Well, why don't they point to where in the sale agreement there's a requirement that they sue the seller? Of course, there's no such provision. So we'll have a chance to debate what was the scope of this agreement, whether Mr. Olderman was personally a party, and so on. None of that was the basis of the summary judgment motion. Those issues weren't decided by the trial court, and it's not appropriate ground for this court to affirm the trial court.
All right. Thank you, Mr. Knight and
Thank you.
Mr. Goldammer, for your arguments. We will take this matter under advisement. That concludes the morning docket.